Section 149 company needs to have a board of directors. Every company shall have a board of directors, which is of the individual as a director as shall have. Minimum number of three directors in the case of public company, two directors in case of private company, one director in case of one-person company. Maximum 15 directors, provided the company may appoint more than 15 directors or passing a such resolution. Provided further the class of companies as may be prescribed shall be at least one woman director. Every company exists on before the due day of date of commencement in the Act shall within 1 year from the commencement apply with the requirement of the provisions of Section 1. Every company shall have at least one director who is stayed in India of a total period not less than 182 days during the financial year. Provided that in a newly incorporated company acquired under the subsection shall apply the proportionate of the every at the end of the financial year in which incorporated. Provided that the case of newly incorporated company requirements in the subsection shall apply proportionately at the end of the financial year in which incorporated. Every listed company shall have at least one-third of the total number of directors, independent director, and central government may prescribe minimum number of independent directors as may be class and class of public companies. Explanation for the purpose of the subsection: the any fraction containing one-third or one-third number shall be rounded off to one. Every company exists on before the date of commencement of the act shall within the 1 year of commencement of the date or the date of notification of the rules as may be application combined with the requirement of provision of 24. So every listed company shall act one-third of the company. Okay. Independent director and central government prescribe number of independent directors may be class of public companies. Independent director relation to the company being director other than managing director or holding director or nominee director. The independent director cannot be a managing director, independent director cannot be a holding director, independent director can be a nominee director. So his option on the board opposing his integrity and possession relevant expertise and experience. Who is or was not a promoter of the company or holding subsidiary of the company. So promoter of the company or whatever who are not related to promoters or director of the company or holding such as a so the person can't be related to promoter, related to director, related to any it's a holding company, subsidiary to associate company, can be related to associate company. Who has or not pecuniary relationship other than their remuneration as director having transaction not exceeding 10%, who has a not-pecuniary relationship other than the remuneration, as with the director having transaction not exceed 10% of the total income of the amount as members credit. So 10% of the total income they should not have. If they have, that is, then he can't be director. If this company holding subsidiary associate company, the promoter director during the two preceding financial year, during the current financial year, none of those relatives. It is holding any securities it is holding any securities or interest in the company, or is holding a subsidiary or associate company during the two previous immediate preceding financial year during the current financial year. So the individual director can have any relatives. So holding securities or interest in the company or holding security as a company to immediate preceding financial year during the current financial year. Provided the relative may hold security interest of the company, the face value should not exist 50 lakh rupees or 2%. 3 lakhs rupees they can hold are paid up capital of the company, holding subsidiary or associate company as my or such higher can some as may be prescribed. It is an intended to company or holding subsidiary or associate company of its promoter, or the promoters or director excess of amount has been prescribed during to immediate preceding financial year during the current financial year has given a guarantee or providing any security in connection with the indebtedness of any third person to the company in the holding or subsidiary of such company as a promoter, director, or such a holding company such for such amount as may be prescribed during the two preceding financial year or during the current financial year, 2 years. So the current year, 2 years, 3 years. Has any other pecuniary transaction or relationship with the company or the subsidiary or its holding or its associate company amounting to 2% or more than gross turnover or total income singly or combined with the transaction ever to 1, 2, 3, this 3 wholly which is causes 2% now then no or who's neither himself nor his relative. He should not he and his relatives neither himself nor who neither himself or nor of his relatives himself should not be indebted, and relatives also it complains of holding or having a position of key manager person or is or have been employee of a company that is holding subsidiary of a company in any of the three financial year in the preceding year financial in which proposed to be appointed. Then you can propose that case relative who is the employee The proposed case of a relative who is an employee restriction under this clause shall not be applied to the employment during preceding relationship. So relatives employee is understand is or he has been an employee or a proportionate or a partner in any other three financial years immediately preceding three financial years in which proposed to be appointed a form of auditor or a company secretary or a practice or a cost auditor or a company of his holding person appointed. If he is an independent auditor, can be an employee, a proprietor, or a partner in any of the three financial auditor office work பண்ணா or company secretary work பண்ணாலும் he can't be eligible. Any legal or consulting firm or have or any legal consulting firm that had or has any transaction with the company or is a holding transaction with the holding company or transaction with the subsidiary company or associate company amounting to 10 percentage of the gross turnover, then it can't be. The holding together with the relatives 2 percentage or more of the two voting power of the company. So holding together it's relative 2 percentage or more to the voting total voting power of the company. Then he can be available. And as a chief executive officer or is a chief executive or a director by whatever name called of any non-profit organization that receives 25 percentage or more of the deposit of the company of the promoter of its promoters, director of the holding or the subsidiary or also the director promoter or director of the whole team, promoter director of subsidiary, promoter director of associate company, or promoter director hold 2 percentage or more in total voting power of the company. If he is related to them or a chief executive, then he can't be an independent director who possesses such other qualification as may be prescribed. Then he can be. Every independent director shall at the first meeting of the board in which he participates as a director, therefore, at the first meeting of the board in every financial year, whenever there is a change in the performance which may affect the status of an independent director, give the declaration that he meets the criteria of independence of the provision of the class 6. For example, for the purpose of this section, a nominee director means a director nominated as a financial institution pursuant to provision of the law of time being forced as an arrangement or appointment of any government or any or appointed by any government or any other person to represent its interest as nominee director. Again, the company or independent director shall abide by the provision in the schedules for scheduling a follow. Notwithstanding anything contained in the provision of the Act, subject to the provision of Section 197, 198 of independent director shall not be entitled to any stock option or may receive remuneration by way of fee provided under the Section 197. Reimbursement expenses of particular participation in the board and other meeting the profit relating to commission as may be approved by the members. So only they can be eligible for that. Other than that, reimbursement of expenses is eligible not entitled to any stock option and may receive remuneration by way of sufficient service provided by him and reimbursement of expense or participation in the board or any other meeting or a profit relating to commission as may be approved by the member. You know, particularly that if a company has no profit or a profit is inadequate, independent director may receive remuneration exclusive of any fees payable under the subsection 5 of 197 in accordance with the provision of Schedule 5. Subject to the provision 152, independent director shall hold the office in terms of 5 consecutive years on the board of the company, 5 years in company, and shall not be eligible for reappointment on passing a special resolution of the company and disclosure of such appointment on the burden, but shall be eligible for reappointment upon a special resolution of the company. Notwithstanding anything contained in subsection 10, no independent director shall hold office for more than 2 consecutive years. For such an independent director shall be eligible for appointment after the expiry of 3 years of the concession to become an independent director, provided that independent director shall not, during such period of 3 years, be appointed in be associated with the company in any other capacity, either directly or indirectly. Explanation for the purpose of the subsection 10 and 11. The tenure of independent director as a date of commencement of act shall be counted in the terms of the declaration, notwithstanding anything in the act. An independent director, non-executive director, not being a promoter, independent and independent director is a notwithstanding anything in the act. Annex 1 in the independent director. Point 2. A non-executive director, not being a promoter, not being a key managerial person, shall be held liable only in respect of such act or omission, act of commission by the company which has occurred with the knowledge is accorded the attribute through the board process and with his concern or conveyance whether he had not acted diligently. So on his whatever he done, he is responsible. In the provision of the subsection 6 and 7, provision of section 7, section 152, respect to retirement of director by rotation shall not apply to the appointment of independent director. Exemption, modification, and appointment. In the case of Section 8 company, Section 149, the purpose provision of section shall not apply. So, Section 8, a government company, 149 not apply. In the government company, Section 149, the board, the Ministry of Department of Central Government, which is administrative and charges of the company. As the case may be state government can be substituted. In the case of government company, clause section 6 shall not apply notification. So, these are the case of clarification of prospectus filed on internal adjudication proceeding initiated independent director, non-promoter, non-key person, non-executive directors. Special measure of companies act saying something neutralized partnership are substituted by the company's amendment. Section 149, Section 3, in other words, every company shall have at least one director who is staying in India for the last period, allotted period not less than 182 days in the previous year. The following class will be substituted, namely, every company shall have at least one director who stayed in India for total period of not less than 182 days in the financial year. Provided in the case of newly imported company, rectification under the subsection shall not apply proportionately in the financial year which are incorporated. Substitution of the Companies Act amendment effective. Okay. Peculiar relationship. The following clause shall be substituted, namely the peculiar relationship other than a remuneration is a director or having transaction not exceeding 10% of the total income or such amount as may be prescribed. And substitution of the Companies Act. Okay, none of the relatives had a happen relationship or transaction with the company. In total, subsidiary associate company, a promoter or director amounting to 2 percentage or more of the gross turnover or total income or 50 lakhs rupees. Higher amount as may be prescribed, whichever is lower during the two immediate preceding financial year or during the current year. Following classes substituted namely none of the relatives in holding any security in the company holding a security or associate company during the two preceding financial year. During the current financial year, provided the relative may hold security interest in the company for his value not exceeding 50 lakhs rupees or 2% of the paid up capital company or a holding subsidiary or associate company as such higher as may be prescribed. It is interpreted to the company or holding a subsidiary or associate company, a promoter or director exceed such amount as may be prescribed during the two immediate preceding financial year or during the current financial year has given a guarantee of providing any security and the independence of any time three period of the company holding subsidiary of the company or promoting director of such a holding company as the amount as may be prescribed during the two immediate preceding financial year or during the current year as the other peculiar transactional relationship with the company or subsidiary as a holding or associate amount of 2% amount of the gross turnover or total income singly or combined with the transaction of 1, 2, 3. Thank you.